Do we know where Keith is? Let's go on the record as calling number 401-0513-2015, the state of Texas versus Enrique Arochi. The state is present, defendant is present with counsel, jury's back in the jury room. Mr. Roller or Mr. Fortenberry, Mrs. King, whoever wants to handle this brief charge conference on the record for this state, have you all received the latest draft of the proposed charge of the court?
State's received the charge, Your Honor.
Have you had sufficient time to review it?
Yes, Your Honor.
Do you have any objections, corrections, or requested instructions?
No, Your Honor.
Mr. Myers, you handling this for yourself?
Yes.
Have you guys received the latest draft of the proposed charge of the court?
Yes, Your Honor, we have.
Have you had sufficient time to review it?
Yes, Your Honor.
Do you have any objections, corrections, or requested instructions?
Yes, Your Honor.
Right.
First of all, Judge, before we get to that, we would again move the court for an instructed or directed verdict based upon the failure of the state to prove the allegations contained in the indictment beyond a reasonable doubt. I understand the court's ruling on that is that it's overruled.
Never had somebody make that motion at this stage in the proceedings, but if you needed to handle the ruling, your motion is denied and overruled.
And Judge, just for the record, we re-urge the motion in regards to the constitutionality of the statute, all the same grounds and reasons that were stated earlier, nothing additional to add, but we just re-urge it after the close of all.
That motion is denied and overruled.
Judge, in regards to the jury charge, the first thing that I wanted to go over was that we would move the court to require the state to make an election between the three alternative means of of aggravated kidnapping. I understand that those are, the state's announced early on that those were counts and not paragraphs. But those were paragraphs and not counts, I'm sorry. But in this particular case, we believe, or our position is that the state should be required to make an election in regards to those three alternative means. And the reasoning being that in the event that there's a jury verdict of guilty, it would be impossible to tell whether the jury unanimity in regards to any of the three submitted versions of aggravated kidnapping. On appeal, if that should occur, if the court were to find that there was insufficient evidence as to one of the particular manner and means of the aggravated kidnapping, it would be impossible to tell if there was jury unanimity as to the sufficient ground for that particular charge. So based upon that and the due process clause of the 14th Amendment, we would ask the court to cause the state to make an election between those three alternative grounds, manner and means of aggravated kidnapping.
So I understand the law that is not required to request this matter overruled.
Judge, we also would request the court or object to the court's charge for its failure to include the lesser included offense of kidnapping and also the lesser included offense of unlawful restraint under Law&Crime versus State at 936 Southwest 2nd, 690 LAPA RRY. It's a case that recognizes that those two charges are lesser includes of aggravated kidnapping. And in this particular case, we believe our position is that the evidence in regards to the aggravated kidnapping elements is so weak that a juror could find, reasonably based upon the evidence as it's been presented to him, that the lesser included offense is, if he's guilty of anything, he may be guilty of the lesser included offense. So we're asking the court's charge to include the lesser included offense of kidnapping and also the lesser included offense of unlawful restraint.
Have you heard Mr. Arochi?
Yes, Your Honor. The state does not believe that the jury has heard any evidence that might show that the defendant to be guilty only of the lesser offenses of kidnapping and unlawful restraint. We do accept the premise that both of those offenses are lesser included offenses of the offense charge, but they're not raised by the evidence.
So I understand the law, Mr. Marks. In order to be charged on a lesser included, not only does it have to be contained within the elements of the proof, which it is, or they are, but there has to be some evidence that if the defendant is guilty of any offense, he's guilty only of the lesser. The only way that I can see the jury getting to any lesser charge is to disbelieve testimony on some other element. And the Court of Criminal Appeals has made it abundantly clear that that is an insufficient reason to grant a lesser included request as to money of the book.
Judge, in regards to the court's charge on page 2 under general definitions, we object to the inclusion of the language under the paragraph that commences, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. We object to the inclusion of the language after the word conduct where it first appears, that being where it says or to a result of his conduct, as being an incorrect statement of the law as it applies to this particular offense. Our position is that the proper instruction of the jury in regards to intent would be the person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in conduct, period. And then in regards to the next paragraph, we object to the court's charge as it gives the definition of knowingly, and we would submit that the correct charge in this particular offense would be a person acts knowingly or with knowledge with respect to the nature of his conduct or the circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. So to the degree that the proposed charge includes that last sentence that says a person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result, we object to the inclusion of that language in that paragraph. So the objections to the inclusion of the or to a result of his conduct or cause the result in paragraph regarding intent, and object to the last sentence of the paragraph as it relates to the motion.
I understand, U.S. Judge. Mr. Ron, you would be heard.
Your Honor, I believe the terms restrain and abduct, as defined by the legislature, include both nature of conduct and result of conduct. We believe that the court's instructions are correct.
Your objection is denied and overruled. Anything else, Mr. Fox?
Yes, Judge, we, on page page 6 of the court's charge, the first two paragraphs that commence in all criminal cases the burden of proof is on the state, and then the next paragraph that commences the fact that a person has been arrested, confined, or indicted for. Those two paragraphs, we object in that they don't track the language of Penal Code Section 2.01, and we would request that the court's charge track the language of that particular section, which reads as follows. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. That's that objection.
Mr. Fowler?
Your Honor, we believe that the burden of proof is properly assigned to the state of Texas by the first sentence. The remainder of the portion that Mr. Myers has pointed out accurately tracks Section 2.01, except for it substitutes the word person, instead of he. We believe those are the fully functional equivalent of the legislative language.
So objections denied and overruled. I do request an instruction as to that.
Yes. Lastly, Judge, we would request that the jury charge include a definition in regards to the term terrorize, and we would submit to the court that the charge should include a definition of terrorize as follows. Terrorize means to fill with terror or anxiety, to coerce by threat or violence, to place a person in fear of imminent bodily injury. That's a requested definition that we're asking.
What is your source of that requested definition?
There is a case, Arevalo, A-R-E-V-A-L-O, it's 749 Southwest 2nd, 271, where it discusses the giving of the definition of terrorize. The court in that case, I believe, gave a definition of terrorize. The defendant complained about it, and the court quoted this language as to what Webster's felt like terrorize means.
I was going to say, I've read that opinion. Is it the quote just quoted from the dictionary?
Yes.
Yes.
I think the point of it is, Judge, I think it's related to, in part, of our challenge to the constitutionality of the statute, in that the statute does not give adequate guidance to the jury in what the term terrorize means. And our position was that if all of the acts that occurred to substantiate the commission of the offense of kidnapping occurred, it would be hard to imagine a situation where terrorize did not occur in that situation. The code specifically does give definitions that relate to terrorizing, for example, offenses like terroristic threat. So the requesting of a definition of terrorize, I think, heightens the awareness that it may have a common meaning, but in the sense that it's used in the aggravated kidnapping statute, it takes on a specific meaning as it relates to that being an aggravator. And I think without a definition given, a juror may give it some definition less than what the court's intended to have in regards to making it an aggravator, to make it aggravated kidnapping. So I don't have a case that necessarily says that it's error to not give that definition, but it does relate to and is part of the constitutional argument regarding the vagueness of the term terrorize. So if that helps.
I understand your position, Mr. Ford. Excuse me. Mr. Rother.
Your Honor, the legislature didn't choose to define the word terrorize in article in either section 1.07 or in the chapter 20 where kidnapping is defined. We think it's a term of ordinary and common understanding that it need not be defined by the court. Moreover, any definition the court did come up with for it might be later construed by some other court as a comment on the evidence. In general, the Court of Criminal Appeals approach to extra statutory definitions has been one that disapproves of definitions outside the statutes that the legislature drafts in the last 20 years or so. Arevalo is a 1988 case out of the San Antonio Court of Appeals. It's not really binding precedent for the premise that the defense offers before. We ask that you can adopt.
I agree that the Court of Criminal Appeals has made it abundantly clear to the trial court of this state that they really hate it when we go defining things that don't have definitions in the code. We requested instructions on how to make a vote.
Finally, Judge, we would ask the court to include an old definition that I understand is no longer the law, but I think it should be. And that's the instruction regarding circumstantial evidence. The evidence should exclude every other reasonable possibility, probability in order to find the defendant guilty or worse to that effect. I think the court's familiar with what that old standard was.
I'm old enough to remember when that was a legitimate charge. It is no longer a legitimate charge. It's no longer something that is approved of by the appellate courts of this state. I'm not in the habit of giving juries instructions that I know to be wrong, okay? Especially if they are an incorrect statement of the law. That request is not on the vote.
I believe that's it, Judge. That's all we have in regards to the charges.
Last night when we were chatting, the guys said you needed 45 minutes aside. Mr. Barker?
Yes, Your Honor, we began asking for 45 minutes.
Work for you, Mr. Barker?
I hope to not need it, but I would respectfully request 1 hour.
Why?
I have a lot to say, it's a short answer, but I hope to come under that, but just to go over what I think are the major points. I don't know, we've been going for 2 weeks, so I'm just asking for at least up to an hour.
Your opening statement was about 53 minutes, if I remember correctly. You covered every major point, and you covered a number of things that are now not in evidence. Respectfully, that request is denied. No more will give up 45. Mr. Fortenberry, you guys going to be splitting argument?
Yes, Your Honor, Ms. King is going to open the state's argument, and I will conclude the state's argument at the end of my portion. If you could give me 2 warnings, one when I have 10 minutes remaining, and a second warning when I have 2 minutes remaining.
Ms. King, you want any kind of warning?
No, sir.
Defense splitting final argument?
No, sir.
Okay. You want any kind of a warning?
Could you please do 10 and 3?
Yes, sir. All right, gallery, listen up. As soon as this jury comes into this room, nobody's in this room, nobody's out of this room. You're glued to your chairs, except for the all-rise portion. because I'm not going to have a final argument disrupted by you guys moving, shuffling, coming and going. If you can't sit still for at least an hour and a half, this would be a really good time to leave. Or I'll go to a jury file. What's going to happen next is I'm going to read my written instructions. After I read my written instructions, the parties will have 45 minutes aside to make their final arguments to you. Because the state of Texas has the burden of proof under Texas law, they get to open and close the final arguments, meaning they get to go first, they get to go last. The attorneys have asked that I tell them when they've used a certain amount of time or when they have a certain amount of time left. So if you hear me chiming in, it's not an editorial comment on it. Think of me as a street sign. That's all. I don't know what the lawyer's request. Read nothing into it other than that. After the attorneys have finished their final arguments, you'll take my written instructions with you back to the jury room. Any exhibits that have been admitted, you want them, we'll send them back. When the 12 of you who will be deliberating this matter are on that side of the door, my bailiff is on this side, and that door is shut. That's when we begin deliberations. If you have a question, or you reach a verdict, you'll knock on the door, we'll take it from there. Ladies and gentlemen of the jury, the defendant, Enrique Arochi, stands charged by indictment with the offense of aggravated kidnapping, alleged to have been committed in Collin County, Texas, on or about the 30th day of August 2014. To this charge, the defendant has pleaded not guilty. You are instructed that the law applicable to this case is as follows. A person commits the offense of aggravated kidnapping if he intentionally or knowingly abducts another person with intent to inflict bodily injury on him or violate him or abuse him sexually or terrorize him. Restraint means to restrict a person's movements without consent so as to interfere substantially with his liberty by moving him from one place to another or by confining him. Restraint is without consent if it is accomplished by force, intimidation, or deception. Abduct means to restrain a person with intent to prevent his liberation by secreting or holding him in a place where he is not likely to be found. Bodily injury means physical pain, illness, or impairment of physical condition. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct, when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or the circumstances surrounding his conduct, when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct, when he is aware that his conduct is reasonably certain to cause the result. Person means an individual. Individual means a human being who is alive. You are further charged as part of the law in this case that the state is not required to prove the exact date alleged in the indictment, but may prove the offense, if any, to have been committed at any time prior to the presentment of the indictment, so long as said offense, if any, occurred within 5 years of the date of the presentment of the indictment. You are further instructed that the date of the indictment, that the day the indictment was presented and the date of the offense, if any, occurred, shall not be computed within the 5-year limitation period. Voluntary intoxication does not constitute a defense to the commission of crime. Intoxication means disturbance of mental or physical capacity resulting from the introduction of any substance into the body. Now, bearing in mind the foregoing instructions, if you believe from the evidence beyond a reasonable doubt that the defendant, Enrique Arochi, on or about the 30th day of August 2014 in Collin County, Texas, in Collin County and state of Texas, as alleged in the indictment, did then and there with the intent to inflict bodily injury on Christina Morris, intentionally or knowingly abduct Christina Morris by restricting the movements of the said Christina Morris without her consent so as to interfere substantially with her liberty by moving her from one place to another or confining her with the intent to prevent her liberation by secreting or holding her in a place where she was not likely to be found, or then and there with the intent to violate or abuse sexually Christina Morris, intentionally or knowingly abduct Christina Morris by restricting the movements of said Christina Morris without her consent so as to interfere substantially with her liberty by moving her from one place to another or confining her with the intent to prevent her liberation by secreting or holding her in a place where she was not likely to be found, or then and there with the intent to terrorize Christina Morris, intentionally or knowingly abduct Christina Morris by restricting the movements of said Christina Morris without her consent so as to interfere substantially with her liberty by moving her from one place to another or confining her with the intent to prevent her liberation by secreting or holding her in a place where she was not likely to be found, then you will find the defendant guilty of the offense of aggravated kidnapping and so say by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict not guilty. You are further charged, as to the law in this case, that the venue for the trial of the offense of aggravated kidnapping is in the county in which the offense, if any, was committed, or any county through, into, or out of which the person kidnapped, if they were, may have been taken. The burden of proof is on the state to prove venue by a preponderance of the evidence. The term preponderance of the evidence means the greater weight of the credible evidence. Now, therefore, even if you find from the evidence beyond a reasonable doubt that the defendant did commit the offense of aggravated kidnapping as alleged in the indictment, but if you find the state has failed to prove venue as alleged by a preponderance of the evidence, you will acquit the defendant and say by your verdict not guilty. In all criminal cases, the burden of proof is on the state. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at his trial. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case or any witness therein, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case or any witness therein from any source other than the witness stand. In deliberating on this cause, you are not to refer to or discuss any matter or issue not in evidence before you, nor talk about the case to anyone not of your jury. And after the reading of this charge, you shall not separate from each other until you have reached a verdict. You are the exclusive judges of the facts proved by the credibility of the witnesses and of the weight to be given to the testimony. But you are bound to receive the law from the court which is herein given you and to be governed thereby. In a criminal case, the law permits a defendant to testify on his own behalf, but he is not compelled to do so. And the same law provides that the fact that a defendant does not testify shall not be considered as a circumstance against him. You will therefore not consider the fact that the defendant did not testify as a circumstance against him, and you will not, in your retirement to consider your verdict, allude to, comment on, or in any manner refer to the fact that the defendant has not testified. After argument of counsel, you will retire and select one of your members as your presiding juror. It is his or her duty to preside at your deliberations and vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have retired to your verdict, you may use one of the forms attached hereto by having your presiding juror sign his or her name to the particular form that conforms to your verdict. Suitable forms for your verdict are attached hereto. Your verdict must be in writing and signed by your presiding juror. Your sole duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you are to restrict your deliberations to that issue. And it's signed this date by me as a judge presiding. Final page are the verdict forms. You will choose one. The verdict forms reads as follows. We, the jury, find the defendant guilty of aggravated kidnapping as charged in the indictment, and there is a line for the signature and a line for the printed name of the presiding juror. Or, we, the jury, find the defendant not guilty, again with a line for the signature and a line for the printed name of the presiding juror. Each side will have 45 minutes for final argument. Mrs. King?
May it please the court, counsel for the defendant, ladies and gentlemen of the jury. Where is Christina Morris? We don't know. 2 weeks ago, when we started this journey, this trial, Mr. Fortenberry got up here in an opening statement and said, we don't know. But we're not required to show you or prove to you where she is. We're not required to prove to you what his motive was in doing this to Christina. We are required to show you who kidnapped Christina Morris in the early morning hours of August 30th of 2014. And the evidence in this case points to one man and one man only, Enrique Arochi. You heard a lot of evidence in the 2 weeks that you were here. Most of it put on by the state. It's our burden of proof. We welcome that burden. But we put all that evidence on to show you the extensive investigation, the stellar investigation by the officers from the Plano Police Department. And it truly was. I mean, it truly took nearly the whole department. Everybody had a part. Everybody did something. No stone left unturned, no tip left not investigated. And why? Because they are confident in their case. They're confident they've got the right guy, Enrique Arochi. And so when you hear all this evidence, you look at it and you say, well, why did I hear all this? Because any possibility that it's anybody else just simply isn't there. So when we talked 2 weeks ago about the elements of aggravated kidnapping, Mr. Fortenberry talked to you about what you thought maybe coming in prior to jury service, what you thought maybe an aggravated kidnapping would be. We think it's someone being grabbed and pulled away, and y'all found out it could be something very different. It could be something like his example about you tell someone under false pretenses, hey, we'll do this, and then you take them. We'll go to the football game. We're going to watch a game at the bar, and then I'm taking you to the Cowboys game. But I'm not a Cowboys fan, and I don't want to go. But if you get me in there by false pretenses or by force or intimidation, that's without consent. And so when he gave you that that example is to show you that kidnapping is more than what everybody thinks it is. It doesn't work in this arena every day. And you heard from all the officers that testified about their theory of the case. And their theory was that Christina got into his car voluntarily. What did he tell her? What was the premise? We don't know, but we're not required to show you that. But she got into his car voluntarily because we know that only 2 minutes pass from the time we see them walking into the parking deck until the time we see the car going out. But when you go back there and you decide this case, remember, the only thing the state has to prove are what's in these instructions. And remember what Mr. Fortenberry told you all in voir dire, that there's 3 different ways that the state has alleged that he's committed aggravated kidnapping. The intent to commit bodily injury, the intent to abuse sexually, or the intent to terrorize. Now it's with the intent. It doesn't have to show that it actually happened, but that was his intent. Okay? And so some of you can think, yes, bodily injury based on the evidence that I heard. And some of you can think to abuse sexually, intent to abuse sexually. And some of you can think that it was to terrorize, the intent to terrorize. So all of you don't have to agree it was one of those 3 things, but all of you have to agree it was one, whether it be the first, second, or third. So some of you may have different ideas or how you interpreted the evidence. So all 12 of you don't have to think it's one, all the same one. It could be a combination of that, as long as you all agree. The other thing I'd like to talk about is venue. Because there was talk, and Mr. Gore asked a lot of the witnesses about, well, Denton County is about 5 miles from the shops at Legacy. How do you know it didn't happen there? And the judge instructed you on venue and what venue is, that if the crime starts in the county and finishes in another county, we've proven venue. But that's just another rabbit trail that the defense wants to lead you down. What do we know in this case? We know a lot about Christina. And you wonder maybe why all those people were put on to talk about Christina. It's because Christina isn't here to speak for herself. And so all of you needed to know a little bit about Christina. And what do we know about her? She had family and friends that loved her dearly. A lot of her friends testified she was the light in the room. She was fun. She was outgoing. She had a good job. She was going to get a promotion at work. All those good things about her. And she was someone who was afraid of the dark. She wouldn't walk anywhere alone, and she certainly wouldn't get into the trunk of a car. And those are the things you needed to know about her, to know that this would be out of character for her to be in the trunk of his vehicle. But the one thing Christina didn't do, she didn't pick the right guy, Hunter Foster. And at 23, maybe you don't know yet, you know that the bad guys aren't the ones you want to end up with, but Hunter Foster is who he is. He's a drug dealer. And they want so badly for you to believe that Hunter Foster was behind Christina's disappearance. And it's ridiculous. And there's absolutely zero evidence to support that. And how do you know that? Well, we know from Hunter Foster's toll records that yes, he was in Plano. He came up about 10:30, 11 that night, the 29th, and then the toll records show he's turned around and he's gone back down the tollway, back down to Dallas. And how else do we know that, in spite of their cell phone expert? Because his cell phone is pinging off the tower in Plano, but when he's back in Dallas, it's pinging off the towers in Dallas. So they want you to believe Hunter Foster is involved. He got immunity, he got this, he's responsible. In order to believe that, you would have to ignore every other piece of evidence presented to you in this court today. And there simply isn't any evidence that supports that Hunter Foster had anything to do with Christina's disappearance. But perhaps what's telling and what started this is, remember the testimony of Anna Morris, Christina's mom. Anna said she called Enrique Arochi after his 4-day head start ahead of the police. And she had that parent's intuition, because she was asking him questions and knew he wasn't giving her the truth. And she just knew something was wrong. And she said to him, we're calling the police, expect a call. And when he told Anna Morris, I don't know what happened to her, we went our separate ways. That was the first thread in the web of lies he started spinning with respect to the disappearance of Christina Morris. And when you look at all the evidence, it leads you to one conclusion, and one conclusion only. That Enrique Arochi is responsible for Christina Morris's kidnapping. He's guilty, and find him guilty for that reason.
Mr. Cole?
Your Honor, would you please to that?
Computer?
Thank you. Yes, sir.
Judge, can I get a time check before Mr. Court begins?
36 minutes, 35 seconds.
Thank you.
Good afternoon. I've been told by people I admire and respect that I have a face for radio, so you can imagine how excited I am right now. But it's not my purpose right now to try to just completely persuade you my way. I would love to do that. In my experience, though, you've got a good understanding of the facts, a command of the issues. And so if I may be of any service to you right now, it would be to walk through for you some of the important aspects of the law and the evidence that was brought forward in this trial that may be helpful for you in your deliberations. And you can see I've got a little PowerPoint, third time I've ever done it now. It's becoming quite a habit. But at the beginning of this entire process in jury selection, I've told you the only thing that matters in a criminal case is, can the prosecution prove the words in the indictment? And the drill sergeant has given you instructions now that no one's at liberty to reject them. I think you've seen that I was shut down a few times by the drill sergeant and didn't like it, but that's the way it is. Same for you now. You have to do what he says. So I'd like to begin by talking about this concept. Has the state's evidence proven the words in the indictment beyond a reasonable doubt? Allow me to say something at the beginning. There's not a person in this courtroom that doesn't have a broken heart for the Morris family. Christina is missing. It's unimaginable. Hey, but you'll see no consideration or ability to take that into your deliberations. This is a difficult process, and you are called to charge a hill, fix the bayonets, and see if the state's evidence can do what they said it could. So we discussed if you hear all the evidence and you're saying to yourself that you simply don't know if anything happened. If that's where you find yourself saying, look, I don't know, even if you think something happened, I don't know what, the verdict is not guilty. A question to ask yourself is, did the prosecution keep their promises to you? In opening statement, Mr. Fortenberry wrote some big checks, very specific about exactly what he was going to tell you happened in this case, about when consent is given and when it's allegedly withdrawn, and all kinds of stuff. So ask yourself, has the prosecution delivered on their promises? So you've heard several different competing theories in this case from several different witnesses, and I want to go over that with you. And the importance and relevance of that, I think, will come through. But the first theory that the prosecution advances is that if something happened, it all occurred in the garage. That's not at all what Mr. Fortenberry said in his opening statement. He told you that nothing happened in the garage. He tells you it was 1 minute. Ms. King now says it was 2 minutes. You know they're walking in at 3:55 and the car's leaving at 3:58. So 3 minutes in there. But one thing that they've done for you in their opening statement is told you this first theory has no legs. The second theory that you've also heard witnesses sponsor is this idea that Christina wants to go somewhere or do something with Enrique. She voluntarily gives consent, but then later on something happens and changes and she withdraws the consent. So you can see here the prosecution is basically admitting with these different theories they don't know. Even if you think something happened, they can't give you any explanation. So let's take a look at these different theories. Under the first theory, again, if something happened, it's in the garage. And to support that theory, they want to bring you particular pieces of evidence. So to go with this theory, they want you to think that she's okay to drive, right? Because if she's okay to drive, she would have gotten in her car and driven, but for something going on in the garage. You remember all the questions of all the witnesses and the receipts? You know, who had the least amount to drink? Did you all think she was okay? Stephen Nickerson saying, we were there at Paulina's house late in the night. I thought she was fine to drive. Remember Detective Benzik analyzing some video footage and telling you her gait appeared normal? What is all this an effort to do? First theory required them, they wanted to prove she's okay to drive. Another big feature of it is under the theory number 1, they want there to be damage to the Camaro when it's seen leaving the garage. Why? They want to argue to you that there's an event happening in the garage that causes damage. How else do you know that they wanted theory number 1 at some point? They go to the garage and they spray this blue star. They're looking for blood evidence. Of course, they don't find any, but this is how you know this was their theory. So the second theory, she wants to go somewhere with him, she's voluntarily consenting. And for that theory, the type of evidence that they want to prove is that she was not okay to drive. You heard Detective Benzik say he thinks that she knows herself. Now, I don't know from what that is derived, but he is willing to express that opinion to you unsupported by any evidence. But in this theory, they want her to need a ride, you see? And in this theory, they want to say to you that there's no damage to the Camaro when it's leaving the garage. Why? To argue to you damage occurs sometime later. So, what kind of evidence did you have in support of this first theory? Detective Stam, at a pretrial hearing in January of 2015, swore to the judge across the hall the most probable thing was that the alleged offense happened in the garage. So see, there you go. She's sponsoring theory number 1, which Mr. Fortenberry completely repudiated and said is impossible in his opening statement. She also said, Detective Stam in her sworn testimony in January 2015, that when the Camaro leaves the garage...
Objection or facts outside the evidence.
Okay.
We ask that Mr. Gordon remove that from his slide.
Take it down, Mr. Gordon.
Okay, so you can imagine my surprise when the prosecution stands up an opening statement and tells you what they told you. Because I'm envisioning a time or a case where I'm going to defend theory number 1, right? You're saying that something happened in the garage? Okay, I'm ready. I've consulted experts, witnesses, in my own investigation. I'm ready. So under this theory, this is the first time anybody's suggesting that Christina wants to hang out with Enrique and that there's this consent being withdrawn. They can't tell you where or when or why. So this alternate theory is being developed without any new evidence. And that's the point I was asking. I know I wore you out sometimes with these witnesses and I covered the same ground over and over again, but this is why. I just want to know what you're saying happened, please, so I can defend him, please. So 0 evidence, but they go all in on it, don't they? And so there I am. Lucy and the football. So let's keep looking at the first theory. Lieutenant Wise testified the first day of trial. All right, he supervises Detectives Busby and Stam, and he said that he helped them develop this theory, and his sworn testimony to you was the offense was complete when the Camaro exits the garage. So Lieutenant Wise, anyway, is telling you something different than the prosecutor's telling you. Lieutenant Wise also tells you that the police's theory has not changed over the course of the investigation. Clearly it's changed at some point. So it appears that, and there are several other witnesses we're going to get to, it doesn't seem like all the detectives and officers are on the same page with the DA's office. Detective Epperson, 35 years law enforcement, 33 of those with Plano. I ask him, You want to make sure you don't have multiple competing theories out there, right? Answer, yes, right. Question, you wouldn't come to a jury with different theories because you're inviting them to say, if you don't know, how can I, the juror, know? And his answer, yes. Detective Spillman, over 20 years at Plano. Similar questions, similar answers. You do not want to change your theory. Detective Spillman understands this concept, is if the police don't know, how can you know? They don't have any right, the prosecutors, to ask you to fill in the blanks, to do their job for them or to guess. There needs to be a unified theory, and this is it. And it's against what the court is telling you to do to try to help them along or fill in the blanks. That's their job. So I've mentioned this, the surprise. I'm not asking you to feel sorry for me. I'm hoping that you will see that when we have a situation where the people pointing their finger at you can't decide, that's a problem. Lieutenant Wise continues to testify. He believes all the police witnesses will agree on where and when the alleged offense occurred. If the police pick a new theory or a new horse, would that concern you, Lieutenant Wise? Yes, that would concern me. Lieutenant Wise understands that if the police and prosecutors can't get on the same page and agree, they don't have any right to come to you and make you do it, beyond a reasonable doubt at that. So let's cover, as we look at the events that evening, because you've heard the prosecutor say, they're going to try to show you that he has formed an intent in his mind. It's his specific desire to violate or abuse sexually, to cause bodily injury, and to terrorize. So let's look at the evidence about how Enrique was that night. What was going on? Every single witness who was out with that group at the shops at Legacy, they all swore to you that from the beginning of the evening until they leave, he's polite, he's friendly, happy, sociable, he's having a good time. No one noticed anything odd or unusual. He wasn't threatening, he wasn't aggressive. And what did Stephen Nickerson tell you? If he had half of 1% of a concern, he wouldn't have allowed it. He would have objected and said, no, don't go walking with him, he's acting crazy. So, but it's from this evidence that they're now asking you to decide that this individual who has been described that evening is acting like a gentleman. There's not been any issues. That it's some unknown place and time, they can't tell you. They just can't, but they're saying somewhere, somehow, at some time, we know that in spite of all this evidence about how he's acting, he forms an intention to do these things. Well, what's the evidence? What did they try to wheel out here to make you think that he has an intention to violate or abuse someone sexually? Well, you heard Detective Busby yesterday say that you can see Enrique walking to the exit of the garage. They've parked there, the group's getting there, and there's a group of people walking. And Enrique comes up and puts his arm around Sabrina. And the next screenshot we see, 30 seconds later or so, his arm's not there anymore. And from that, they come to you and they say, that is proof beyond a reasonable doubt of an intention to commit sexual assault. The other thing that I think you might hear is, well, Sabrina and Enrique, they're talking on the couch there. Sabrina says, I want to go to sleep. And Enrique says, okay. And she says, well, I want to be on the couch. And he says, no. So she gets in bed with Paulina, right? She doesn't say Enrique's hot-tempered or upset about it or anything. And in fact, what does Sabrina do? She's texting Enrique about 12 hours later, hey, can we hang out tonight? So clearly, this idea that he's formed an intent to commit sexual assault, you don't have any evidence of that. How else can we know that the prosecution's, it's an educated guess, or I don't even know if it's educated. How is their guess? How do we know it's flawed? Well, the interior of Enrique's car was thoroughly processed. It's swabbed for DNA evidence several different times. They're applying these alternate light sources to it. They're looking in that thing like crazy. And what's the evidence that you have about what they discover from the interior of his car? Nothing. Nothing related to Christina Morris. And you remember my questions, Detective, are you willing to just say that the fact that there's nothing related to Christina Morris, all these hairs you're finding in there aren't her, no DNA, no nothing. Are you willing to just tell me that that's some evidence, just some evidence that she was not in the passenger seat? No. They can't do it. They know that if they admit that to you, they got a big problem. But you don't need them to admit it to you for you to know the obvious truth. So let's talk about the DNA evidence in this case. And how do we get it? I take a lot for granted. I've been reading this file for, a year and 9 months. And you're hearing it for the first time out of nowhere. And so I know it's hard to process it all, but here's the testimony. September 3rd, criminalist Boble is processing Hunter Foster's car there at Plano PD. An hour later, she is inspecting and photographing Enrique's Camaro there at Plano PD. Well, Morris's DNA is in Hunter's car, and that's not much to ask you to believe. So the next day, September 4th, Boble and Detective Stammer processing Morris's car at the Plano Police Department. A few hours later, they're processing Enrique's, same criminalist, same garage. They're right there doing it. Now, they say, no, we're not wearing the hazmat suit or the Tyvek suit. We just have gloves on. We're not wearing booties. Everything was fine. But this is a one bay, one garage, and you've got all these cars coming in and out. And there's going to be some more in a minute where we'll talk about issues regarding transference. So, soon after, we see that Morris's car is there, and then here's Enrique's car. And this doesn't, nobody needs to tell you this. This is how cross-contamination occurs. And what are we talking about in this case? You heard one of the state's witnesses describe for you the quantity, you remember that, of the DNA evidence? And you remember I asked him, what are we talking about here? And he says picograms. And a picogram is 1/1,000,000th of a gram. So what's a gram? Common household measurement, I asked him. A packet of sugar. So imagine opening a packet of sugar and pouring it out and divide it up into somehow divide it up into a trillion different parts. Clearly you can't see it, right? We're talking about infinitesimal, hardly anything. Okay, this is the type of DNA that's being tested. And we know, we're going to get to it in a minute, that the DNA that they have, it's not blood. We know that. What about the trunk mat? You remember the testimony for that? It's put into a box, and the box isn't sealed. Ms. Wilson, she testified yesterday, the head of the CSI storage unit, she said an unsealed box left in the property room is a breach of protocol. That's not supposed to happen. What do we know? This box is put into the HOM locker on September 29th. What else do we know is going on September 29th? Detective Sam's putting personal items of Christina Morris's into the same HOM locker. Do you remember the photograph? All this is in evidence, you can see them, but they're photographs when they're processing Enrique's car and they put a flashlight down there to get a view underneath the seat. Well, the testimony was that's how they process cars. So we've got tools that are being used in everybody's car, and the idea that we're going to transfer potentially just a trillionth of a gram becomes, it seems to be more in the realm of possibility, doesn't it? Okay, let's talk about the damage to the Camaro. So the prosecution's second theory, it puts them in a real bind because they need that car to be undamaged when it's leaving the garage for this second theory to work. And they asked several different witnesses, did you notice, was it damaged, did you see anything? And most of these people said they weren't paying attention. One witness said that she didn't think so, but she couldn't be sure. All right, so obvious questions. Are any of these people inspecting the Camaro and paying attention to it? I mean, it's a fair question to ask, I get it. But there are other cars parked right next to the Camaro that would obstruct your view when you get out of whatever car you're getting out of. And think about their ability at that moment in time to perceive and remember events. They're back at Petrosky's drinking shots of 100 proof Captain Morgan drum. There's been evidence of tequila drinking. So I think it's a fair deduction to say that their powers of observation were less than optimal. What else do we know about this damage issue? Blake Sawyer, he's their video expert who analyzes video in the case. He testified that the area around the right fender well appeared to have a different reflective value than the other areas. Of course, indicating that the Camaro has damage to it when it's leaving the garage. And those are the photographs that I showed you either yesterday or Friday. You'll have them in evidence to look at in your deliberations. It's very clear that there is an issue going on in this area in terms of the reflection of the light. In that exact area where the prosecution says there's not damage. Have they proven to you beyond a reasonable doubt this issue of when the damage happens? Now, right, the theory's not working. We need the damage to be, we don't need it there in the garage under this second theory. So now Sawyer comes to the stand and he says, I can't tell. I tried, I just can't say either way. So in other words, they just can't prove it. They can't prove when this damage is happening. All right, so how else can you know that the damage to the Camaro and the injuries on Enrique's hand and arm happened before he went out to the shops at Legacy, before they go out? You remember Alex Buheider? I spelled it wrong. Alex Buheider, he testified to you, and he told you that before he went out that night, see, Enrique's texting or calling him, I think it was a phone call, I believe Alex testified to. He says, hey, I'm going to be out at the shops tonight. I know you live close by, come join up. And Alex testified that in that conversation, Enrique is telling him he hurt himself. Detective Busby admits that if there was some evidence out there that he had injured himself before they went out that night, that would affect your theory. But you'll recall the way it was answered, if you had a witness. Well, thankfully she's under the rule. I guess she didn't know what Alex had testified to. We do have a witness who confirms that these injuries are before Enrique goes out. All right, so let's play along here. If the car is damaged somehow after it leaves the garage, then please tell us where that happens. Please tell us how. What proof do you have that the damage happened the way you say it did? Are you asking this jury to speculate? Do you remember this evidence? My preference is not to do a lot of objecting because you get it, you know what's going on. But do you remember, I think it was Officer Sasso saying, there's no way you could there's no way you could cause damage to the Camaro with your forearm or elbow. You just can't do it. But what did he tell you could cause it? A head. Please consider, are you being asked to base your decision on reason and common sense? Or is there an effort at all going on here to try to inflame you? So here's the bottom line. I mean, this is where we really are. As far as the cops know, he's the last person seen with her, so he just must have done something is the idea. But even under that, if you were to grant them that for the sake of argument, there's been no evidence of the what, when, where, or how. So they cobble this accusation together, and in support of it, they speculate and guess. We've spoken about this. Okay, so all the witnesses say no concerns about Enrique at all. No evidence to support this claim that there's an intent to commit sexual assault. And the last bit there goes without saying, doesn't it? If that's what makes an intent to commit sexual assault, then we're all in trouble. So let's talk about Hunter Foster. You remember Foster swore that he was testifying in this trial before you because the prosecution promised he wouldn't be prosecuted for anything related to Christina Morris. Foster claims he was at the Concrete Cowboy Bar at the W Hotel August 29th and 30th. You've had no evidence to confirm his whereabouts. None. He says that he saw Logan Prendergast at the Concrete Cowboy. Can't see it too well there. What did Logan testify to you? He wasn't there. He wasn't there. He didn't even go to that bar. Foster claims he was with Taylor Berry and Ellen Etheridge on August 29th and 30th. Taylor Berry never came to court to testify to you. Ellen Etheridge never came to court to testify to you in corroboration of Hunter Foster. No banking records, no credit card records, nothing to help Foster in this claim that he is where he says he is. What do you have? Cell data hits. You've heard the testimony about that today and the reliability of that in terms of saying a particular phone is at a particular place. So the next day, Hunter Foster's cell phone activity. There's no text activity from 3:55 a.m. until 4:54 p.m. Okay, 3:55 a.m. is when Enrique and Christina are walking into the garage. There's no phone call activity on his phone, 4:58 a.m. until 4:41 p.m. Detective Stam says she sees nothing odd in this. I understand these facts are unhelpful to their one of several theories, but these are the facts. So yes, Plano police, they went out and interviewed him. Sure, we talked to him. Are we really investigating him? Well, we know that on September 3rd, they're immediately sticking a tracking device on Enrique's car, like right out of the gates. They've already decided we got our guy. Well, Hunter's there on the same day. How about put a tracker device under his car? Let's see where he's going. They did undercover surveillance, follow Enrique around. When he takes a sip of a soda, they take the can or the straw. There are no searches done by Plano and Tarrant County. He didn't call or text anyone about Christina. You remember that? He's getting calls from Christina's co-workers that Saturday. Where is she? She was supposed to come to work today. He's not responding. He's not answering. And he's not doing any of this. I think the evidence was until late on September 2nd, like around 11 p.m. It's the first time he reaches out to somebody and says, hey, got any news on Christina? The police admit to you, he is the most likely suspect in a missing person case. He's the boyfriend. You see, the thing about Hunter Foster is it requires no assumptions. Okay, Foster claims that he's at the Concrete Cowboy and the W Hotel on August 29th and 30th, and we know that that's not true. Pardon me. He says he was never outside the area of the uptown area in Dallas. But you know that's not true. The prosecutor gives you his North Texas total authority records. He's in Addison and Plano. He testified to you, I never went north of 635 that day. Remember that? I never even went north of 635. Well, he's still not telling the truth about that. We know he was selling drugs to an undercover officer at Jaguars on August 29th. All right, so I'm sticking with this. An opening statement, I never promised you it was my mission to prove, beyond a reasonable doubt or otherwise, that Hunter Foster is directly responsible. Not my job to do it, I'm not trying to do it. What's the point I'm making? The prosecution has to prove beyond a reasonable doubt that he's not in some way. And not him necessarily. What about his connections? What about the people he owed drug money to? There are a lot of unanswered questions about that. According to LaTerrence Dunbar, this is the gentleman you heard from yesterday.
There are facts outside the evidence.
Stay.
Would ask it to be removed from the
Take it
screen.
down, Mr. Cole. You argue outside the evidence again, it will be a problem.
Okay, well, I think the evidence was LaTerrence Dunbar said that his employment is that of providing personal security for individuals. He's talking to Christina for 30 minutes. Hunter walks up and her tone changes. It's very obvious that she just shuts down, was his testimony. So he didn't want to testify. He refused to do so without immunity until the U.S. Attorney's offices for these districts promised not to use his words against him for drug conspiracies. And the Collin County DA's office says that they also will not use his words against him for anything drug-related. Those were questions Mr. Fortenberry asked on his examination of Mr. Foster. Okay, but that's not the only reason he agreed to answer their questions. There's a quote, some of you I know have heard of it, that cross-examination is the greatest legal engine ever invented for the discovery of truth. All right, and there, I had an exchange with Hunter Foster I think that was helpful. I asked him, you saw assurances from the DA's office that you would never be prosecuted for anything related to Christina Morris before you would agree to hit that stand. Isn't that true? And his answer, okay, I don't know what's in Hunter Foster's mind, but it seems like in his mind he didn't want to get up there unless he was promised. Okay, what did the prosecutor, the official agreement, we're not going to prosecute you for drug offenses? Well, ask yourself this question. If Hunter Foster is completely excluded, just completely, why not give him what he thinks he's got anyway? Why not give him immunity for anything related to Christina Morris? He's not a suspect. But they're not about to do that. They're not about to offer him immunity for anything related to this. All right, so here's some points to consider I think that would be helpful. The prosecution wants you to think that anytime Enrique misspeaks or misremembers or says something that isn't 100% accurate, that's evidence that he's guilty as charged in the indictment. Okay, but the state's witnesses, are they held to that same standard? Okay, all of the partygoers, they forgot or confused events of that evening. It's obvious why. But none of them could remember exactly how much they drank. Some of them couldn't remember which bar they went to first. Some couldn't remember, you remember this? Some of them could not remember which parking garage they parked in, just like Enrique. Some didn't remember who was in Sabrina Boss's car when she dropped off Justin Hill and Bree Lofton and James. And do you remember, there were a couple of witnesses that couldn't remember if there were 5 or 6. Somebody said that they sat in the very back where there's not a seat. Other people said nobody was back there. Okay, obviously they're not all liars. Of course not. They had been partying, and it's been 2 years, and they get mixed up. They're human. But when Enrique does it, it's proof beyond a reasonable doubt that he did the words in the indictment. So, is this type of double standard fair? I'm not asking that Enrique you not evaluate the statements he gave. Of course you'll do that. That's completely appropriate. But they're holding him to a standard and they ask you to hold the other witnesses to a different standard. So Enrique gets a call from Detective Sam on September 3rd. He's at work. You heard the conversation. And he gets her number and he says, give me the address and I'll meet you there. And sure enough, he gets off work and he goes. And when he gets there, he says, yeah, you can look at my car. I'll sign the voluntary consent form. The form that tells me you're going to look in my trunk. The form that tells me anything in here can be used against me. He has no problem with it at all. He answers all their questions. He didn't ask for a lawyer. He didn't have to talk to them. And he lets them photograph his body, not just his arms and hands, which he's wearing a short-sleeved shirt. So it's not like he was trying to hide the obvious injuries he had. And then they say, well, pull your shirt up and turn around and do all that. I'm speculating they thought this would be a big reveal and you were going to see some big evidence, and there's not. So he goes again the second time on September 3rd. They call him, come back in, we got more questions for you. This is when they put on the tracking device. And at that time, they had their suspect. They had it. And so on September 4th, he's been twice on the 3rd, and now he's going back for the 3rd time on September 4th. He again allows them to photograph his car, and now they're processing it. They could have processed it the day before. They say we didn't have somebody there to do it, but it's not like Enrique was trying to prevent it. They again ask him questions, and he answers. He's wearing short sleeves again. Okay, so let's move on. You remember the prosecutor told you that there are 3 main things to consider in this case. You're supposed to look at the evidence in light of these 3 factors: video, DNA, and cell phone evidence. So let's take a look at the cell phone evidence. This is one of their 3 pillars. Okay, the prosecution's witness in this regard is Detective Benzik. Okay, here's the question. He's an eminently likable officer. There's no question about it. But in August of 2014, he's on neighborhood patrol. He's a foot officer. Somebody drinks too much, they get arrested for public intoxication. Steal a handbag from Kate Spade, he'll take you in. And now he makes detective in January of 2015, and he's become an expert in cell phone tower analysis. Hey, but you heard the testimony today from Robert Aguero. And you heard all the you saw the maps that were introduced, and Mr. Benzik says, I agree, those maps are fine. I've got no issue with those. But what Benzik was asking you to do was, hey, these are cell tower data hits, and we know that means that the car's within 3 miles of there. And that clearly is not the right explanation for cell tower data usage. It'd be one thing if these were text messages we're talking about, or phone calls, but we're not. And so either Detective Benzik on his examination when he's answering questions from the prosecutor, he either doesn't know that or he didn't want to do a full explanation of it. All right, so either way you're being asked to trust his analysis. And in light of Mr. Aguero's testimony, I think it's clear that this data hits whatever you... Okay, I think it's clear that type of evidence is unreliable. Detective Stam and Detective Busby both agree if the analysis isn't right, then that's a problem. And this entire theory that Enrique's car, we know it gets on the toll road, it exits at the Custer Road gantry. Okay, we know that. What it does after that is a complete guess on their part. What they want to say is we have cell tower data hits that around 4:50 a.m., 4:27 a.m., and that means that his car is back in this area. The evidence has not shown that at all. They're not entitled in any way to that kind of assumption. I mean, you saw it. There are 3-minute spans at around 3 in the evening or 2 in the morning, 3 in the morning, and Enrique's getting cell tower data hits 80 miles away towards Fort Worth, 50-something miles away. These data hits are all over the place because it's Sprint network doing internal processing. It's not a phone use event such that you can decide where somebody is. And along these lines, doesn't it make sense that Enrique, why would he go to his neighbor and say, hey, I know you got a camera there by my garage. Would you mind checking it out at 4:30? Because the police are really on me now, and I'd love to show them since I know you have a camera. Okay, one, he wouldn't ask that if he wasn't home at 4:30. That's ridiculous. And how long does it take to get if you leave at about 3:58 a.m. back to Allen? I don't know, 20 to 30 minutes, just depends. They're asking you to trust Benzik's analysis beyond a reasonable doubt. And imagine if you had not heard from Mr. Aguero today, how you might view the cell phone data records and analysis. Did the police officers strike you as objective fact collectors? Or based on their answers, did it appear at times that they had an agenda, that they have a preferred outcome here? They can do that, but it seems to me that would call into question their motives in the investigation. Do you hear Detective Stam on Friday? She says it. Oh, maybe the injuries were a bite mark. If she knew in October 2014 that Dr. Paula Brummett told her unequivocally it's not, and yet they're still saying it. They know there's not blood evidence in the trunk, but if they won't admit it, what the criminal is Susan Hassan, and you remember the James Bond guy, Neil Carnes? What do they both swear to you? If it's a blue star reaction that's faint, it's not blood. Do you remember that Carnes said he had never seen a less impressive blue star reaction, the faintest he had ever seen? What's that telling you? Well, it's some evidence, they won't even acknowledge it, that it's not blood. But then it goes off to the lab, and what's the lab say? Not blood. I bet you anything in a minute you're going to hear them argue that it was. Okay, Erica Scott, the head of the CSI unit, she testified about the blue star reacting, confirming everything that you've already heard, that it was faint. If it's faint, it's not blood. Right, so the official certified labs that conduct blood testing in this case, they tell you it's not. Why are we having this argument? Right, you remember Detective Garcia, he says he places a tracker under Enrique's car, and it's the cleanest thing he's ever seen. It's like coming off the showroom. So I asked him, if a witness comes in and says we found debris and plants underneath there, then we'll know it happened after you inspected it. And what does he say? Oh, no, I only looked under a couple of areas of the car. Oh. Hey, Benzik, he didn't collect any videotape past, I think his testimony was 7 to 8 a.m. on August 30th. Just stopped. We just don't need any more of that video. No video anywhere. Maybe there's no video of the Camaro coming back to the shops at Legacy under their theory. Just maybe there's no video of that because the Camaro didn't come back. And you're asked to take his word for it, just like you were asked his whole video analysis. You're supposed to take his word for it, just like you are on cell phone data. He even admits you can get out of that garage on foot without being seen on a camera. These just seem like obvious points to me. Maybe there wasn't an event in the car. We have no evidence that there was. Nothing about the interior of the car indicates any kind of struggle. No rips or tears, no footprints on the windshield, nothing. All right, then there's this whole business about, well, he filled up with 7 gallons and a few days later he got some more gallons. This is where we're at. He's guilty because he's pumping up a couple of times and it's not the normal routine. This is the quality of evidence they're asking you to base your verdict on. All right, Morris texts Hunter, I'm going to take a taxi home. Benzik says there were taxis and cars for hire in the area at 4 a.m. There was even a green Kia Soul in the area circling around. If you're using an Uber app, okay, we're not going to see that on your phone records. And you know from common experience, Uber drive right up to your feet. Benzik just couldn't identify the driver of that car. Okay, so here's just briefly on this Collin County thing. Let's assume for the sake of argument, let's just assume you think something happened, that in some way you think it's a kidnapping. Hey, they haven't even proven Collin County. That's why the judge is giving you this instruction. All they say is that this data usage event is near the Granite Parkway. Officer Sasso says 2.9 miles to the west, Denton County. And even Sasso and Stam admit it. They don't know when or where or what. But if you want to play along with them, they admit they can't prove where. They all say it. We don't know. I can't have been the one that pointed this issue out. There's no way that I'm the one who alerted them to this problem in their case. So can the police and prosecutors really be wrong in a case like this? Do you remember juror number 80 in jury selection, Mrs. Boyle? Her mother was abducted and she was murdered.
Facts outside the record.
Stand.
We ask you to remove the slide.
Stand.
You're all right, just by way.
Take it down.
Okay, I need to pass through here. Okay, how do wrongful convictions happen? In circumstantial evidence cases just like this, when juries are being asked to base decisions on less than proof beyond a reasonable doubt, okay, presumption of innocence. The law has already signed the verdict form for you. The only way that it changes is if you erase it. That's if you find the words have been proven beyond a reasonable doubt. And we saw this. So what's clear and convincing evidence? It's the kind of evidence that gives you a firm conviction or belief in the issue to be proved. You believe a firm conviction and belief beyond a reasonable doubt is more than that. What more than that is it? That's up to you. But this is not supposed to be an easy process. This is not supposed to be something where you just issue out a guilty verdict. The law intends for this to be hard for you. Okay, who do these rights protect? Presumption of innocence, proof beyond a reasonable doubt. Well, they obviously Enrique. Okay, but they protect you. Do you understand what they're asking you to do something that they don't have the power to do? And the law says before we're going to put our citizens in a position to make these kinds of decisions, we're not going to ask you to do it unless the evidence is so convincing beyond a reasonable doubt. You don't want to have to worry about, am I doing the right thing? You don't want to think about every time you hear on the news a story, does this call into question what you've done here? There it is. It's what I've always said. The judge just read it to you, as charged in the indictment. Okay, so here's what the drill sergeant is telling you. They have to prove each and every element beyond a reasonable doubt. Okay, this is a photo. You all taught me something in jury selection, because I looked at that picture and I thought number 2's the winner. And some hands went up and said, not so fast. And I really appreciated that, because I had my blinders on. I thought this picture perfectly illustrated the point I wanted to make, and thank you for teaching me that lesson. I hope that that's the type of analysis that you will bring to the state's evidence, because they want you to, this is representative of their case, isn't it? See, there it is. We got evidence. See right there. Well, hold on now. Hold on now. Prove to us. Prove it. Okay, and here we go. Okay, if you look here on the left, I'm going to suggest to you that that's Plano Police Department. Yes, Your Honor. They see 4, and let's just say you can understand their perspective. The problem is they refuse to even see the possibility that it's something else. I asked Detective Busby, you have an unfalsifiable theory. There's nothing I can do or say that's going to change your theory. And that's where we're at. So I'd ask you to please stand the wall, guard it, really look at what the judge is asking you to do, the instructions that you've been given, and analyze it. Please look at all of this. I'm not afraid of an inch of this. The evidence is not there beyond a reasonable doubt, and I would ask for your verdict of not guilty. Thank you.
Fortenberry, 36 minutes and 35 seconds.
Yes, Your Honor, just a moment to prepare the courtroom.
Can you use your camera?
Yes, you switch to my computer too. Thank you, Judge. May it please the court, opposing counsel, members of the jury. Where is Christina Morris? I told you at the beginning of this case I wouldn't be able to answer that question, and we haven't. Where was Christina Morris? In the defendant's trunk. We've answered that question, and the scientific DNA evidence has proven it. That when you've got DNA in your trunk, it's evidence that she was inside of there. And when the surveillance camera catches you at a place you say you're not, with someone you say you've already left, you're in trouble. And when your cell phone pings side by side next to hers, when you say you're already home, that's evidence. And when you couple that with bruises and scrapes on your fist and damage to your car caused by a human, it's proof beyond a reasonable doubt that you're guilty of aggravated kidnapping. Now, Ms. King has told you and the judge has explained that the aggravated kidnapping law is quite broad, and it's meant to encompass a whole series of types of factual scenarios. From the very minimal, from someone just holding you back and saying, get in my car and go, to ripping someone up off the street, tying them up and putting them in your car. There's a lot of broad spectrums. Before I go any further, I have a few things that I just disagree with Mr. Gore about, and I want to just air it to you right now. There doesn't have to be one consistent theory. In fact, the judge has given you 3 possible theories that you don't even have to agree on. Intent to commit sexual assault, one theory. Intent to terrorize, second theory. Intent to commit bodily injury, third theory. And you don't have to agree. So the premise that you have to agree is just flatly false. And throughout the course of this trial and during my closing arguments, I've done my best to give you the facts like I see them, to not provide spin, and to not try to trick you. The defense has tried to trick you. They've used words very carefully and quite cleverly. And here's just a couple of examples. He had a slide up there and he told you there was no text messages from Hunter Foster's phone for 12 hours. Is that true? There were no SMS text messages, but the cell phone extraction that Detective Benzik reviewed, and he told you about iMessages that are on the data record, that's not true. And so when the defense makes a bold claim that there are no text messages, can you trust him? And then they quote Blake Sawyer up there, but they put the quotation marks very carefully. Because he had a bullet point that said, different reflective values, end quote, indicate damage. You see, that's not what Blake Sawyer testified to. When the quote ended, that's the end of Blake Sawyer's testimony. He told you he couldn't be sure, but the defense just runs right over that. I'm not here to trick you. I'm not here to pull the wool over your eyes. I'm here to give you the facts. And to tell you that on August 30th, this defendant kidnapped Christina Morris, and that's what the facts say. And you're right. There are 3 things that you should measure every single piece of evidence by. I told you in opening statements, and I want you to keep them to you closely. You can take those to the bank. And any theory in this case must survive an analysis of a filtration of those 3 things. First, the video surveillance. We know that the video surveillance is reliable. It captures what happens. It tells us when people are together, when they say they're not. It also gives us timestamps. Things that we can know can be accurate and relied upon to put in context of when other things are happening. And I'll tell you that in this case, the best thing for you to look at is States 54. 54 is the example of the 19 different segments that are relevant to this case. And finally, there's a summary that puts them all together of the last few minutes of the defendant and Christina walking together. States 54 is video surveillance that you can trust. You also can look at States 109 and the associated Kroger video that's with it. This is video surveillance that the next morning the defendant is washing his trunk. And that's unusual. Video surveillance is stuff that you can trust, and every theory must surpass the test of does it corroborate and line up with the video evidence. Next, we have cell phone pings. And if you didn't think this evidence hurt the defense, now you know why they called Mr. Aguero and paid him the money to come up here and tell you what he got paid to tell you. Because the cell phone pings are important. And the best thing for you to look at with the cell phone pings are these 2 diagrams that Detective Benzik put together. It's a series in State 76. Those are of Enrique's phone. And in State 77, those are of Christina's phone. And you know what? You don't have to trust just Detective Benzik on this. Because Detective Benzik will tell you that he ran this by the radio frequency engineer, Kiran Prakash, the man you heard from Sprint. And Kiran testified to you, he reviewed that work, and he stands by it. Those cell phone pings hurt the defendant so much, they tried to pay someone to distract you. They tried to pay someone that tells you in the intermittence of a data action, there is transfer. But guess what? They didn't ask him what it means at the stop at all. And when I asked him, you've testified on behalf of defendants before in support of cell phone records, when it helps your case, he didn't want to answer that question. I had to ask it 3 times before he told you a simple yes. The cell phone evidence hurts the defense, and they've done everything they can to distract you from it. But what they can't distract you from is the DNA. The DNA is the evidence that we know puts Christina Morris in that trunk. And every possible theory they've put out there about how her DNA could have gotten there is by touch DNA transfer. Well, every scientist in this courtroom told you that that was not touch DNA. So none of their theories work. And do you really think that Plano Police is running such a poor shop that things are just getting contaminated across the board? Every theory that they put about DNA and contamination deals with touch DNA. That one person touched something and it transferred to another, and that's how you're supposed to believe it or not rely upon it. But that's not true. No one testified that her DNA in the trunk was touch DNA, and to the contrary, Christina Capt and Nick Bradford both testified that it was not touch DNA. The amount was too much. So let's take a look at the defense theories through the lens of these three things. The defense had so many theories I had to write them down, okay? They told you in opening statement that Hunter Foster did it. If Hunter Foster did it, why is the DNA in his trunk? You see, the Hunter Foster theory doesn't match the test of the three things. We know that Hunter Foster's cell phone puts him down in Dallas, pinging, selling to an undercover agent. If you want to imagine a better alibi, try selling drugs to an undercover police officer. We know where he was on the night of August 29th, and it was not at the shops at Legacy. Defense theory number 2, the green Kia. Well, at some point they called it a suspicious green Kia. That's just an adjective they assigned to it. It was Detective Benzik who said, I was noticing that there was a Kia who drove around the parking garage. It never entered inside, and I wasn't able to track it down. If the green Kia did it, why is the DNA in his trunk? You see, it can't surpass the test of these three things that you can rely upon. Defense theory number 3, in their opening statement, they told you that something had to do with the Aryan Brotherhood. Really? They said that to you to get you to step back and to be surprised. They told you it had something to do with Logan Pendergrass. Well, Logan testified. They didn't ask a single question related to that. There's not a single piece of evidence, but they said it for shock value. Defense theory number 4, it happened in Denton County. Again, not a single piece of evidence points to Denton County, and the judge has told you that even if the crime begins in Collin County, that's sufficient. And every single officer has testified that this crime began at the shops at Legacy parking garage. That's in Collin County, and this whole Denton County thing is a defense theory to distract you. Defense theory number 5, that we didn't follow up on our tips. They told you in opening statement that not every tip was followed down. Well, they had Detective Busby on the stand. They had every chance to ask her about a tip and to see what she did to follow up on it. She told you there were 471. They didn't ask her about a single one. And you can infer from that because she had an answer for each and every one of them. And defense theory number 6, DNA contamination. They don't tell you how it got contaminated. They don't tell you what occurred. They just make these questions. And if they ask questions 45 times in 45 different ways, it doesn't make it true. You see, the DNA contamination doesn't coincide with, well then why did he lie about being with her? The video surveillance says otherwise, that they were together. Why did he lie again and again and again? The state's theory has remained true. And let's walk through the timeline to know a few things. But before we get to the timeline, let's take a look at the defendant. What facts can you add to these 3 pillars of the case as a starting off point? Well, the fact is, the defendant pulled into the garage 4 seconds before Christina. 4 seconds. Remember what he told Detective Stan? I don't know where she parked. That's what he told Detective Stan. The fact is they parked facing each other, 1 spot over. He told Detective Stan, I parked in a different garage than she did. And when Detective Stan confronts him, he says, well, maybe I just walked through that garage into the next garage. He gives an elaborate answer. Not just that I don't know. He says, I know I parked in that other garage because my friend Alex lives over there. It's by the pool and the bulls and that statue. I remember it. See, he's creating facts that are lies. It's not just I don't remember. It's actual lies. Fact number 3, there's a conversation between the two. It takes 15 minutes to walk from Paulina's apartment to that garage, and they walk together. There's a communication from the defendant's cell phone to Hunter Foster's in that 15-minute span. He tells Detective Stam, I was calling, and then he changes, says, I was texting my girlfriend. That's a lie. You know that's a lie. The biggest lie of the night, he told his girlfriend he was going to bed at 10:30. Then he says, the truth is, or Detective Stam and the evidence shows the truth is they walked into the garage together. The defendant says, we split up at the end of the apartments. Well, those are just 4 lies. We're not even in the car yet. And he's already told Detective Stam 4 different lies. So why did Christina get in the car? My guess is he lied to her. And if he lied to her to get her consent to get in the car, then that's deception. And the judge has told you that if consent is made by deception, it is not valid. Maybe he told her, I'll take you to see Hunter. That was a lie. He didn't drive in that direction. Maybe he told her, I'll take you home to Fort Worth. That was a lie because he didn't drive in that direction. Maybe he said, I'll get you some Adderall. It's interesting that of all the people they interviewed that night, he is the only person who brought up Adderall to the detectives. He had a prescription. We know that. He told them. So maybe he tried to entice Christina to take an Adderall, or he was going to go get some Adderall. That was a lie. In some way, shape, or form, he deceived her to get into that car because we know Christina. You know Christina. She wouldn't have gotten in the car unless he lied to her. So what do we know from there? If you look at our timeline, you know that as they're walking there, Christina's upset with Hunter. We showed you those text messages. They don't scare us. Christina's talking to her drug dealer boyfriend, trying to get his attention and trying to tell him about drugs, and she can trade this drug or that drug, and maybe she used it. Does it matter? Does it make her any less of a victim if she happened to have used drugs once in her life, or twice in her life, or every day of her life? We know that she's mad about Hunter. She's texting him. She's trying to get his attention. Lost her keys. I'm going to take a cab. Can I even get in the house? Is it unlocked? But the defendant's phone is also talking to Hunter. Through phone calls and text messages, he's a part of that conversation. Whether Christina's borrowed his phone or he's using his phone, there's communication. You notice they didn't ask their cell phone expert about that either, to confirm or deny that Enrique's phone talked to Hunter Foster's phone. So the second part of the timeline is when the crime begins to occur. Because we know that crime happens at some point when they back out of the parking spot. And after that, it's part of the investigation. You have to rely upon your gut. And we talked about circumstantial evidence. You don't check your common sense at the door, folks. When they did a test after test drive of how do you get to that gantry in 10 minutes, there's about one way. You weave through those first few streets, you have to go Parkwood to 121 and drive straight on 121. It's the only way to get there in 10 minutes. Well, the timeline shows just that. And I'll tell you, when they're in the car, something changed. Maybe Christina knew they were going northeast. That's not where she said she wanted to go. Maybe the defendant hit her in the passenger seat and bruised his wrist. Maybe he punched her in the mouth and cut his knuckles on her teeth, but something changed. Evidence is that they turned around. You know it takes 9 minutes to get from that gantry along the access road back to 5800 Granite Parkway, where Christina's phone pings at 4:17. That's not just a coincidence. It's circumstantial evidence that you can take and add together piece by piece. And maybe at some point when they slowed down at the stoplight, she jumped out. And maybe he swerved the car and it hit her, because you know from Investigator Sasso, and you also know from the Huffines collision guy, that's no tire drop, that's no punch, that's more like a head or a hip. Maybe it knocked her out. And maybe while they pinged in that area for 30 minutes, he shoved her in the trunk. Maybe that spot in the trunk is her saliva as she drooled from being knocked unconscious, or maybe it's blood. But then he drove home. And he told Detective Stam, oh yeah, I woke up my brother. Where's your brother? The defense has every right to subpoena anyone they want to be here. Where's the brother? And after 5:30 a.m., he went to dispose of the body. Maybe he drove off-road, looking for a field or somewhere good. We have some vegetation under his car. We know that he drove off-road at some point. Maybe he couldn't find a good spot. Took her to a dumpster instead and just got lucky. You see, I don't know where Christina Morris' body is. We're not prosecuting him for murder because we don't have a body. We're prosecuting him for aggravated kidnapping because that's what the evidence shows. And that's what you've been heard from. And that's what you can trust. But when the defendant starts to get caught, he starts to cover things up. You know that Anna Morris and Hunter Foster called him on the night of the 2nd. But you know he's already washed his car once before that, at the gas station the morning after. He's washed it, both the passenger side door, he buffs that out, and he gets the whole squeegee to take it to the trunk. That's on the 30th. And on the 2nd, when Anna calls him and says, you should expect a phone call from the police. He went to the car wash the next morning. Sometime at 9 o'clock, 9:27, we got the receipt. It's on his bank records. The cover-up had began. And the reason he's so bold to the police is he thinks he vacuumed it good enough. That he scrubbed the trunk good enough so that you would never hear about her DNA. He's wrong, but that's what he thought. So when he told Detective Stam, sure, he can look at my trunk, that's fine. What he didn't know is they would be looking in his trash cans at his house. And if you're going to cover up the crime, why don't you make a list of things you need to get rid of? State's Exhibit 121 is a post-it note found in the defendant's trash can on September the 10th. After Stams talked to him and grilled him, he made a list. And we know this is about Christina Morris because it says a black shirt, exactly what he was wearing. We know this is about Christina Morris because it says August 29th, the night they went out to the shops at Legacy. We know that his bank bills show where he spent money. The Kroger gas station, Cartopia car wash. And we know that his cell phone, those bills are also going to hurt him because they relate to the pings. He made a to-do list of things to get rid of. Is it any surprise that his car is wiped clean? It's not a surprise at all. They found empty bottles of cleaners in his trash. And sure, those are household items that we all use. But in 2 weeks, are you really using another full bottle? How many times did he wash that car and scrub that mat? He tried to cover it up. Never did he ever think that there would still be a sign of DNA in his trunk. He was bold. His girlfriend told you that after he got his car back, he thought he was in the clear. He started giving media interviews. That's what Brand testified to. He had no idea that people in Virginia and in Fort Worth were still working. The people in Virginia and the people in Fort Worth both tell you that the quantity is too high to be DNA. And Mr. Gore can talk about the trillionth of a sugar packet all he wants. The fact of the matter is, that's the size of things we're talking about when it comes to DNA. DNA is not something you can see. And they talked about picograms. Remember what Christina Kapp told you, that the amount of DNA was consistent with a buccal swab, swabbing your cheek. That's how voluminous the DNA was found on the trunk mat. And Bodie Technologies was consistent. They said it was a substantial amount. It's too much to be this touch DNA that every defense conspiracy theory rests on. So what is it? Christina Kapp told you it's most likely from bodily fluid. And DNA from bodily fluid is contained in one of those three primary things: blood, saliva, or semen. We know that it's not semen. She's a female. Is it blood or saliva? When we're talking about the corner of the trunk and the weather stripping, does it really matter? The only one of those two things that reacts to any Blue Star agent, the test that Neil Carnes performed, is blood. It's the only one of those things that would ever respond to Blue Star. And what about that number? 1.7 quintillion. 1 in 1.7 quintillion. That's the scientific probability of selecting someone at random that this would be their DNA, not Christina's. That's something you can trust and rely upon in your deliberations. There's no doubt that it's Christina Morris. This case is probably the most thorough investigation you'll ever hear of. The Plano Police Department gave Detective Busby a blank check. A blank check when it comes to resources, finances, anything she needed. And but for the good work of the people at the Plano Police Department, we wouldn't have the evidence we have. You know, in 2016, it's been a bad year for police officers around the country. There are some places and some locations that they don't like their police officers. There's been riots and protests against them. I'll tell you what, you can respect those police officers. Because the people at Plano Police Department are doing an excellent job. You can be proud of their work. Because do you think it's glamorous for Detective Caballero to be going through trash cans? Do you think that's some glamorous work that he just loves to do? Well, what about Detective Stam? How many times did she have to talk to Enrique and all she wanted was an explanation? All she wanted was an explanation, and all he would do was lie to her. And when she asked, can you just show me what you did? Show me how you did this tire? He stopped talking. What about Officer Sasso, who searched for 10 months every day? And the community volunteers from EquiSearch and the family members and friends on horseback, ATVs, drones, and walking by foot, they searched to no avail. Detective Robin Busby did a fantastic job. She uncovered every single thing. Yeah, a blade of grass, it matters. I want to hear it, I want to see it, I want to test it. Oh, some psychic called? We'll go look. And they want to dismiss this as people with an agenda. That is absurd. But you know who might be the unsung hero of this investigation? I think it's Brittany Vlier-Webb. She's the CSI person who, for the first time, her first activity in this case was on September 29th. No possible cross-contamination with her. She was briefed. She was aware of that video of him scrubbing the trunk, and she thought to herself, well, what would be the area or the location of where I would put something heavy and it would be hard to clean? The weather stripping. And she showed you with her swab how she swabbed that weather stripping all the way down. She put the cap on it, put it in the box, in the envelope, and in the bag.
You have 10 minutes.
Thank you, Judge. Her instincts were right. Where would you put something heavy that would be hard to clean? Christina Morris weighed about 95 pounds, was about 5'3". When he pushed her in that trunk or when he pulled her out to dispose of her body, her blood or saliva touched that weather stripping. And because of the good instincts and the good work of Brittany Vlier Webb, you have that evidence. Sure, we want more. We always want more. In any case, we want more. But sometimes we just get lucky. Those guys who drove through the ATM, they're the reason we have evidence of the defendant backing up. But for them going for the garage, we would have never had any video evidence of the two cars at the same time. But we got it. There's still unanswered questions. Things I'd like to know. I'd like to know what's on that cell phone that was white they picked up from the Sprint store. Heck, I'd like to know that second cell phone. What's on it? I'd like to know what's in Anna, Texas, and why you're driving up there the next day for a couple of hours. What we'd all like to know is, where is Christina Morris? We don't know. And I can imagine that for a family, it would be hard to lose a loved one. And particularly hard when she's in her prime, in her mid-20s, and coming into an adulthood with her college degree and blossoming as a person. But imagine how difficult it is when you can't say goodbye. You can't have a funeral because you don't know where her body is. The only information they know is that the last strips of her mouth or blood from her body were in the trunk of a Camaro. That's what they know. And it must be hard. I'm not saying your job is easy, because it's not. But there's only one reasonable explanation of all the facts. And that's that the defendant is responsible for the disappearance of Christina Morris. And that makes sense. It's why he lied. It's why when the group got back together to retrace their steps, he didn't show up. It's why he washed his car again and again. And it's why the police looked at him. Because all the evidence pointed to him. They didn't have an agenda. They followed the evidence where it led them. And it led them to one person. And that's this defendant, Enrique Arochi. He kidnapped her. And whether it's because he was sexually frustrated, because he lied to his real girlfriend, he got shot down by Sabrina, and this was his one last attempt at the night to score, I don't know. Or whether it's because he intended to terrorize her because he did terrorize her. Driving in the car, not letting her out, taking her to a place she didn't agree to go, or putting her in a trunk when she's scared of the dark. Those are all terrorizing things. But perhaps the most convincing is that he had intent to commit bodily injury. Because as Detective Busby said, there was a fight. It was between Enrique and Christina, and she was fighting for her life. You see, he walked away with scrapes and bruises. She was never found again. That's evidence of bodily injury. The DNA in the trunk is evidence of bodily injury. The evidence is before you. You know what happened to her. You know who's responsible for it. And we're going to ask that you hold him accountable. Tell the Plano Police Department thank you for doing good work and doing a good job and tell the defendant you got your day in court and you're guilty.
All right, ladies and gentlemen, in a second, I'm going to say the door of my jurors back to my jury room, to the two people who are my alternates, not who my alternates are. And, all right, gentlemen, I need you to remain behind. Another 12 will take my instructions back to the jury room. If you want any of the exhibits that are related to evidence, let us know. We will get it back to you. My two alternates will remain behind. Ralph, will take the other 12 out.
All rise.
May I see it? Gentlemen, I have some additional instructions. Each of you is an alternate juror in this case. The jury is now will soon be deliberating, but you are still an alternate juror and are bound by my earlier instructions about your conduct. Whether you will be called upon to serve is unknown. This evening, when I send these people to a hotel, if they are still deliberating, you'll be allowed to go home. I've got a room around the corner for you to be in this afternoon. Do not talk about the case. Do not talk about any of the people or any subject involved in it with anyone, not even your family or friends, and not even among yourselves. Do not view any media accounts or news articles related to this case or subject matter. Do not have any contact with deliberating jurors. Don't listen to any accounts. Don't go online and look up anything about these cases. Stay off of social media. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in this case unless you are substituted for one of the deliberating jurors. You must follow these instructions until you are released from the court. You guys understand these? Dr. Peel, would you take them around to the sign the monitor?
Yes, Your Honor.
Oh, you don't need deputy. All right, we'll be in recess in this matter until we've had some communication from the jury. We're on the record. We're in recess.